Good afternoon, Nighthawks. This is Dr. H. Hey, I'm just going to go through real quick with Chapter 4. Just going to cover some key points. You'll find a lot of these in your PowerPoints, and your reading is really important for Chapter 4, to be quite honest. So let's just dive right in. With Chapter 4, we're talking about the foundation versus substance, or the foundation, which is substance versus procedural law. Before we dive into the mechanics of lawsuits, let's establish an important distinction that will help you understand everything that follows. Substantial law is the what. Substantial law defines the rights and obligations that arise between two or more parties. It's the substance of what law says what you can and cannot do. For example, HIPAA says you must protect your patient privacy. That's the substance. Medical malpractice law says doctors must meet the standard of care. Employment law says you can't discriminate based on protected characteristics. Procedural law is going to be more of the how. Procedural law consists of the court rules that guide a lawsuit from the beginning through the completion, such as the trial, settlement, or dismissal. It's the how of legal proceedings. Examples: how to file a lawsuit, what documents must be served and when, how discovery works, and the rules for presenting evidence at a trial. From there, you'll need to make sure you understand the players in legal drama, such as who's in a lawsuit. And you'll want to make sure you understand who the plaintiff and defendants are, and the differences between a class action, or which is a lawsuit by consumers against a large and generally powerful entity, for alleged wrongdoing. An example in healthcare would be patients suing a pharmaceutical company over side effects from a drug. So that would be a class action. Make sure you understand health information as evidence and the role you play in that. This is where you become the star of the show, so to speak. Health information is used as evidence in a huge variety of legal cases to determine proof and the extent of injuries. In personal injury cases, how badly was the plaintiff injured in the car accident? Just as an example, the medical record will tell that story. In a medical malpractice, did the doctor meet the standard of care? When it comes to workers' comp, was the employee injured on the job? How severe is the injury? In a disability claim, is this person unable to work? Custody issues, is the parent fit to have custody? And this is where mental health records might be relevant, and so on. And so you'll see where you may come into play in healthcare fraud, criminal proceedings, several of these areas. You want to know about pretrial, and this is where most of your involvement happens. Most legal cases never go to trial. They're settled during the pretrial phase, but this is the phase where you would do most of your work as a health informatics professional. There's the litigation life cycle, the filing of the lawsuit, the complaint, which is the document containing allegations filed against defendants, a summons, which is the official notice that a lawsuit has been filed, service, the complaint and summons must be properly delivered to the defendants, and then the answer, the defendant's response to the complaint. You may also see additional legal maneuvers such as a counterclaim, cross-claim, or a joinder. A joinder, defendants bring in an outsider as a co-defendant. For example, a hospital brings in the physician as a co-defendant. Discovery, and this is typically going to be the busiest time for someone involved in a lawsuit. This is the process used to discover or obtain information held by the other parties to assess strengths and weaknesses in each case. Criminal distinction, discoverability, what information can parties obtain during pretrial investigation, and then there's admissibility, what evidence can actually be presented to the judge or jury. E-discovery, or the digital challenge. The federal rules of civil procedure have been updated to address massive amounts of electronically stored information, or ESI, in modern healthcare. E-discovery considerations include native file formats, not just the printouts, computer files, emails, instant messages, metadata, data about data. Even deleted files can be recoverable and included in this situation. You'll want to make sure you understand Electronic Discovery Reference Model, or EDRM. This provides a framework for managing e-discovery efficiently. You'll need to understand that what electronic information your organization has, where it's stored, and how to preserve and produce it when required. Preservation of the evidence, or legal holds. This is when litigation is anticipated and organizations have a duty to preserve the relevant information. This is where things can get serious. A legal hold or litigation hold. This is a court order or internal directive to preserve information that might be relevant to current or anticipated litigation. You'll want to make sure you understand spoliation, the destruction or alteration of information relevant to a legal proceeding. This can result in severe penalties, including fines, adverse jury instructions, dismissal of claims or defenses. You'll want to make sure you understand discovery tools, and the type of discovery requests. You'll want to make sure you understand what a deposition is. Interrogatories, written questions that I cannot talk today. Sorry about that. Written questions that must be answered in writing under oath. Example, describe all the policies and procedures for maintaining patient health records. A request for production of documents. This is something you'll want to know. Physical or mental examinations. Independent medical examination by a neutral practitioner. You'll want to understand what a request for admission is. This is when it's being asked the opposing party to admit certain basic facts that aren't in the dispute. An example would be admit the defendant hospital treated plaintiff on March 2023. There are going to be several tools to compel discovery. Items such as a court order, a subpoena, and with subpoenas, and this is used to compel testimony or production of documents, but initiated by an attorney through the court. And you're going to find that there are typically two types of subpoenas, a subpoena and testificandum. This seeks an individual's testimony. A subpoena duces tecum. This instructs you to appear with documents in hand. You'll want to make sure you understand the elements of valid subpoena, and you'll find this in your book as well as in the PowerPoints. So make sure you go in and you take a look at these items. You'll want to make sure you understand search warrants and when law enforcement gets involved. Items such as a judicial search warrant, a judge-written order authorizing law enforcement to search a specified place and seize evidence. In the healthcare context, this is most likely in fraud and abuse cases where law enforcement believes healthcare providers have committed crimes. There is constitutional protection. The Fourth Amendment protects against unreasonable search and seizures, and this is why this is where the importance of search warrants come into play. Then we go to trial, and this is when cases can't be settled or don't settle. Only a small percentage of cases actually go to trial, but understanding the trial process helps you understand why proper record keeping and evidence preservations matter. You'll want to make sure you know the players in the courtroom, the role that the judge plays, the jury, who the parties are, such as the plaintiffs and defendants, witnesses, court officials, the bailiff, court reporter, clerk of court, and then some of the trial procedures are some of the items that you'll want to be familiar with. I don't expect you to know these forwards and backwards, but I do expect you to be familiar with them at the end of this module. Jury selection, what takes place, if there is a jury trial. What are opening statements, a plaintiff's case, a defendant's case, what are closing arguments, jury instruction, deliberation, and verdict. These are all items that fall under trial procedures that you will need to know. You'll need to understand burden of proof. Usually the plaintiff has the burden of proof. The burden of proof is going to be things such as beyond a reasonable doubt, clear and convincing evidence, preponderance of evidence. Some of the other items that I want you to make sure that you understand when we move into post-trial, what happens after the verdict. There are situations in which there may be appeals, and so I want you to understand the appeal process. Cases may be appealed for review and alleged illegal errors. This can be done by the appellant or petitioner. Collection of judgment. You'll need to understand where or how this works. Equitable relief, which is court orders defendant to do or stop doing something. There's money damages, garnishment, writ of execution, judgment of lien. And then the most common that we know in healthcare is medical malpractice insurance, designed to cover court-ordered money awards. I want you to make sure that you know, let's look through here. Documentation, real-world applications for health information professionals, record management. What are your responsibilities when it comes to record management, legal response preparedness, and evidence preparation? You'll find these in your PowerPoints and also in the readings of your book. There's a lot of really, really good information. And so I want you to make sure that you're going through Chapter 4 and that you understand all these items. And maybe ask yourself, do you know what a legal hold is? Do you know e-discovery? What is authentication, privilege, things of this nature? Let any of these bold words that you see as you're doing your readings or as you are going through your PowerPoints, ask yourself if you understand and if you could answer that if it was on a quiz or in an open book discussion, because some of these very well may. With that being said, that's all I've got for you for Chapter 4. I try to keep this one brief. The PowerPoints are a little bit long. But if there's anything, as usual, if there's anything you need or anything I can do for you, please don't hesitate to reach out. Keep in mind, we try to keep our quizzes and exams due at noon. Other than that, have a great Nighthawk Nation day. We are really rolling through this semester and you're doing fantastic. Thank you, everyone, and have a great day. Bye-bye.